The air inside Durban Magistrate Court was thick with tension as Duduzile Zuma, the daughter of the former president of South Africa, Jacob Zuma, stood accused of crimes that could shake the very foundation of South Africa's democracy. The courtroom was packed. Lawyers, journalists, and spectators waited with bated breath, sensing the gravity of the moment. The state had thrown a book at her. Terrorism, incitement of public violence, and contravening the Riotous Assemblies Act. Serious charges indeed, enough to condemn her to a fate she would not easily escape. At the heart of the case, a handful of social media posts sent into the digital etherwaves nearly 4 years ago at the height of the July 2021 riots that had left a trail of destruction in their wake. Yet, despite the weight of the accusations, the prosecution stood before the court with an unexpected revelation. They did not oppose bail. A murmur rippled across the court. How could the state claim she had incited nationwide chaos and yet concede that she posed no threat if released? Another layer of intrigue emerged: the manner of her arrest. The state had arranged for her to turn herself in, a stark contrast to the usual show of force reserved to those who are accused of such grave offences. The magistrate, his voice edged with skepticism, pressed the state to justify why an arrest was even necessary if Duduzile Zuma posed no flight risk. Was this mere legal formality, or was there something deeper at play? Her defense team pounced on the opportunity, painting the very prosecution's action as nothing short of a political witch hunt, an attempt to manufacture a dramatic spectacle. Was the charge of terrorism a legal necessity, or was it designed to inflict maximum reputational damage? The implications were staggering. To know more about this story, stay tuned.
Yes, you may proceed.
As I indicated earlier, the state is not opposed to bail. The reasons that we have decided not to oppose bail are the following. The address of the accused has been verified. It is recorded in the affidavits. The accused is an employed person, and we have verified the employment. More than that, Your Worship, the accused was aware of the investigation and made comment regarding it some 2 years ago, and is still available and cooperated fully with the state as far as being present in court is concerned today. Even though the accused appears, as it must be in terms of our law, in custody, I can place on record that she handed herself over willingly to the police this morning, and she was processed and brought into court for these proceedings to be held. And on that basis, Your Worship, we do not oppose bail. We do not also consider her to be a flight risk.
Yeah, just one moment. You say that as she was supposed to be law, appear before this court.
Your Worship, the accused is being arrested in terms of a charge that falls within Schedule 6, which gives the court a discretion regarding bail issues, which is why she has been brought after handing herself over to be before the court, so that the court can determine or make a proper determination on the bail issue, despite the fact that the state does not oppose.
So was the applicant then arrested?
Yes, she was arrested. She was placed under arrest this morning.
Without a warrant?
Without a warrant. We contacted her through, I think it was through the political party officers at first, and then we got contact with her legal representatives, and arrangements were made for her to be brought in this morning, which she did, and she presented herself to the investigating officers who went through the process of having her and the matter placed in the court.
I ask that because it seems to be from your address, there's a bit of conflation between the two processes. One deals with the arrest, which is a separate process, and then the issue of remittance of bail or otherwise, which is also a separate process, which is within the discretion of the court.
We did not want to deprive, if that is the word, the court of that discretion, which is why it is customary for us as the prosecution, when a person is charged in terms of Schedule 6, to place a person before a presiding officer in custody. For a presiding officer, as the law requires, to make the determination in the bail process as to whether the onus on an applicant in a Schedule 6 application has discharged the onus of presenting exceptional circumstances in the interest of justice. And it's a process thing that we have, and in the end it's your worship's discretion regarding bail. The state, as I indicated, is not opposed to bail in this matter. Further to that, Your Worship, we have assessed that the accused is not a flight risk, and the likelihood of any interference with witnesses is minimal. We have taken certain precautions regarding the witnesses, which gives us reason to believe that we do not have a fear in that regard as well. Those are my submissions regarding the non-position of bail.
Thank you, Mr. Reid.
If I may, Your Worship, can I just go to the affidavit before I go to the notice of motion? Yes, Mr. President. Your Worship, also with your permission, if I may be permitted to leave out some of the personal details, but obviously they are as reflected in the affidavit.
Yes,
As God pleases. It is as follows. I, the undersigned, Duduzile Zuma, Sambuka, do hereby make oath and state that I'm an adult female born on the dates that are outlined there. I'm applicant in this application for bail pending my trial. First, within my personal knowledge, unless stated otherwise, and to the best of my ability and correct. My next submissions of law and just on the advice of my legal representatives, who gives advice I accept. And the content is as follows, We've, for the convenience of the court, put it in separate headings to deal with some of the requirements of the law. I'll start at paragraph 4. I have been charged with incitement to commit the offense of terrorism and incitement to commit the offense of public violence, the exact details of which are unknown to me, but I understand these charges and the seriousness of the same, and I intend to plead not guilty thereto. That is when the trial starts. 5. Although I have not yet sight of the complaint or the summary of facts, I'm aware of the long-standing rumors and innuendos about the messages which I sent from my social media accounts, mainly on the Twitter platform, in connection with the general uprising which had already erupted in the KwaZulu Natal and Gauteng provinces in reaction to my father's imprisonment in July 2021. Although I do not deny having sent some messages which have been misconstrued, I am of the strong opinion that no court can find that the violence in question occurred as a result or in connection with any incitement or any conduct on my part. The two things are utterly unconnected, causally or otherwise, in any sense envisaged in our criminal law. My conduct was only informed by my particular sense of outrage at the injustice meted out on my own father. This went much further than the objections of his political supporters and millions of other peace and justice-loving South Africans who, like me, did not participate in any acts of public violence, either directly or indirectly. I also hold the strong view that the charges are malicious and politically motivated. They are aimed at settling political scores with my father by the current regime. Evidence in this regard will be led during the trial. Suffice at this stage that I am confident that a case of malicious prosecution will be well and easily established against the National Prosecuting Authority at the appropriate stage. I have instructed my legal representatives to pursue that action. 9. It is plainly nonsensical and petty to interpret words which are used, such as, quote, I see you, unquote, to mean that the people referred to or were influenced by my social media commentary. The mere fact that it has taken the state almost 4 years to work out whether a small number of social media messages constitute, quote, terrorism, unquote, speaks for itself and is an indication that NPA is clutching at straws with a very weak case. 11. I have been informed that the charges proffered against me constitute a Schedule 6 offense and that I bear the onus to prove on a balance of probabilities that there are circumstances, that there are exceptional circumstances, that's what it should do, and that the interests of justice require that I be granted bail. Then the facts are placed before the court. In this regard, I wish to place the following facts before this court, this honorable court. I'm currently residing, I'll also limit the headings in as well, just for the record. Permanent residence, movable and immovable property. I'm currently residing at the address indicated there, where I have been residing for 13 years. The property belongs to the company that's mentioned there, company owned by my estranged husband. I do not own any immovable properties in my own name. That place. I was born in Mozambique, in Maputo, and I am a South African citizen. My ancestral home is KwaZulu Natal in the province of KwaZulu Natal, where my father currently lives. Then under the Gauteng family. I am legally married, but separated and live with my 2 children, namely, and then the names of the children and their ages are outlined there, Your Worship.
Yes.
Following the separation, I am the custodial parent and primary caregiver to my minor children. They both attend school in Johannesburg. Employment. I'm currently employed or engaged as a member of parliament in the National Assembly in Cape Town, having been duly elected as such in terms of the electoral laws of South Africa during the recent May 2024 elections. As a representative of the Umkhonto weSizwe Party, which is the official opposition party in South Africa. I'm also a duly elected member of the Pan-African Parliament, in which I am the Southern Caucus chairperson responsible for the SADC region. My income from membership of the National Assembly and other business initiatives amounts to approximately the amount stated there on average. Now, under the heading, no previous convictions or pending charges. I have been informed of the provisions of section 60, bracket 11, bracket A, and state that I have no previous convictions, nor is there any other pending case against me. No likelihood to endanger public safety or commit Schedule 1 offences. I respectfully state that there is no likelihood that I will endanger the safety of the public or any particular person, nor will I commit a Schedule 1 offence should I be released on bail. The offences for which I am charged were committed almost 4 years ago under specific unprecedented circumstances which are unlikely ever to repeat themselves. Undertaking not to interfere with state witnesses, which my learned friend addressed. I will not make any contact with any state witnesses, nor have I attempted to do so. In fact, I'm not aware of the identities of any witnesses. I also understand that the major part of the evidence is based on transcripts or screenshots of social media messages rather than human witnesses, save possibly for expert and non-partisan witnesses. Any possible interference with such witnesses would be futile and senseless. No flight risk and undertaking to stand trial. I respectfully state that should I be released on bail, I will stand my trial and that I do not constitute a flight risk. In this regard, I place the following on record. 1. This matter goes back as far as 4 years back. It has been lingering in the air for a long time. 2. I was fully aware of the fact that I'm being accused of instigating the well-known unrest and uprising which took place in July 2021, triggered by the widely perceived imprisonment of my father without standing trial. Many South Africans, rightly or wrongly, viewed that as an affront to our constitutional democracy and reminiscent of apartheid-style that seems to be misplaced. Apartheid-style tactics. 3. Despite these allegations against me, and knowing there was a high probability of a criminal case being investigated against me, I have always returned to South Africa. In the circumstances, I submit that the history of this matter clearly shows that I'm not a flight risk and that I will stand my trial in this matter. And then they should deal with the crucial matter of exceptional circumstances in terms of this section from paragraph 26 onwards. In addition to what is stated above, this matter also exhibits the following exceptional circumstances. 1. The evidence will probably be mainly led by experts. Should be an S at the end of it. 2. Unlike all other persons who have been labeled as alleged instigators, I have a blood relationship with my own father, whose imprisonment was arguably the spark of the incidents in question. It is hardly surprising or remarkable that I was aggrieved by his imprisonment. 3. I am an elected public representative of a political party voted by more than 2.3 million voters. 4. My incarceration pending the trial, whose duration in state readiness is unknown, state of readiness is unknown, would serve no purpose. 5. I have pledged to abide by my bail conditions. 6. To the best of my knowledge, no other person who has been charged with the same or similar offences has ever been convicted. Some have been either acquitted or have had their charges withdrawn. Then possible bail conditions and safeguards. I further submit that with adequate bail conditions, any fear in this regard by the state can be negated, including not leaving the country without notifying the investigating officer in this matter, which has been proposed by the state and agreed to by me. That we should and then the affordable bail amount. August 2020. I am furthermore able to pay an amount of 2,000 rand for bail. This is in keeping with the amount of bail paid by other persons facing the same charges in relation to the same incidents, none of whom are members of the National Assembly until 2029, as I am. In the circumstances, I respectfully submit that the Princess of Justice require my release from incarceration, and it's signed, Your Worship, by the accused person, and it's dated yesterday, the 29th of May. But this is, if I may just then quickly go through the notice of motion is the usual preamble, and the order that is sought, Your Worship, is that the accused be released on bail pending the trial in the sum of 2,000 rand, and such conditions of the court deems fit, including the one that I mentioned. I'm indebted to the court. Let's go. If I may just check, please. Let's go, please.
Anyway, I apologize for interrupting. There was an important oversight, and I think it's because we waited so long for the proceedings to start. Before the accused is asked to confirm her statement, can she also be warned that any comments made in the statement may be used against her in a subsequent trial? Yes, as court. I just thought that we had forgotten this non-practice to remind the court.
Thank you, Ms. Zuma Sambuta. Yes, sir. An affidavit deposed to by yourself has been entered by the state court on your behalf in support of your application to be limited on bail in this matter. In the affidavit, just after paragraph 20, actually paragraph 21, on page 5, you disclose that you have no previous convictions and no other charges pending charges against you. I am obliged to caution you that it amounts to a criminal offense to give incorrect information regarding your previous convictions in any country and pending charges. Do you confirm that that information in your affidavit is incorrect? I'm also obliged to warn you that this affidavit, the content of this affidavit, the facts that you have alluded to in support of your release on bail may be used as evidence against you at any possible trial. Do you understand that? Do you still wish this affidavit to be handed in as evidence? You okay with that? Thank you very much. You may be seated. For the purpose of your court, the affidavit by the applicant Duduzile Zuma consisting of some 9 pages, together with the notice of motion making 10 pages, is marked as a page. There is one technical matter. Under regulation, I think it is 3 or 5 of the regulations under the Commissioner of Courts Act. Yeah. The Commissioner of Courts must put their full names and their full business address. It is a technical thing. So I see they understand that the full name appears not to be here, although the course number is here.
Yeah, yes, Worship. We did deal with that actually when the statement was being made, and we were assured by him, as a him, that the stamp, insofar as it indicates the place, the correct place, but is normally sufficient. But Your Worship is quite correct.
So are you requesting that I condone that in view of the stamp?
That's correct.
So you mean no objection to that?
No objection.
Thank you. Thank you, Mr. Deputy.
Thank you, Worship. While on my feet, Worship, I would kindly request the court to order the media in the event that the statement, these days, these things go around, that the parts that were not read out in court should not be published.
Thank you.
That's what.
Welcome back to the Fraud News channel. I'm your host, Boss Robert. Thank you to all those who have subscribed to the channel, liked and commented on our videos. We appreciate your support. To those who have not yet subscribed to the channel, please show your brother some love and click that subscribe button and the notification bell so that you don't miss any future videos. Thank you for your support. Back to the story. The defense did not hold back, questioning the very legitimacy of the charges. For 4 years, the state had been investigating a few social media posts. Duduzile Zuma's lawyer, Advocate Dalimpofu, declared, his voice ringing across the courtroom. And now, suddenly, they emerge with a charge of terrorism. Is it coincidence or is it a convenient timing? The prosecution unfazed, countered with equal force. The posts were not just words, they insisted. They were calls to action, digital matchsticks that had ignited a blaze of distraction across KwaZulu Natal and Gauteng. They referenced prior convictions of other alleged instigators, warning that this was no trivial matter. But when the magistrate pressed them to provide clear prima facie evidence against the accused, the state's case seemed to wilt under scrutiny. Then the moment arrived. The magistrate, taking every word, every argument, every nuance of the case, delivered his ruling. The tension in the courtroom reached a breaking point. Bail was granted. Not with the usual conditions, not with a hefty sum to keep her tethered, but without any financial burden at all. A silent shockwave roared across the courtroom. The magistrate was clear. Justice is not just about symbolism. If the state itself had no evidence to suggest she was a flight risk, why impose unnecessary restrictions? Duduzile Zuma's supporters exhaled with relief. Her detractors fumed in quiet frustration. The ruling was a clear blow to the narrative of an imminent threat. The state had secured its indictment, but in the courtroom of public opinion, the scales had shifted. Though Duduzile Zuma walked free, the storm was only beginning to gather. The case would now move to the High Court in March 2025, where a battle even more explosive awaited. Her defense team vowed to challenge the legitimacy of the charges, while the state prepared to present evidence it had thus far withheld. Would justice prevail, or was this a chess game of political retribution? In the coming months, the answer will be revealed. But for now, Duduzile Zuma had won the first battle in a war that is far from over. Please share your thoughts on these charges and court proceeding in the comment section below. If you have enjoyed the video, please consider liking, and if you have not yet subscribed to the channel, please show your brother some love and subscribe to the channel now. Thank you for watching. See you on the next video. God bless you.